So in this video, I have an update on a major win against a statewide magazine ban. Oregon Measure 114 has been found unconstitutional and struck down with a permanent injunction. And now the Court of Appeals in Oregon agrees and is still going to block this law. So this is a huge win, and we need to talk about what has now happened. Now, real quick before you jump this video, if you agree that magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. As I mentioned in the intro, in this video, we need to discuss a huge win against a state magazine ban and then also a permit to purchase firearms. Oregon Measure 114, which put in place a statewide permit to purchase and also a magazine ban, was ruled unconstitutional and struck down in its entirety. The state court judge there, Robert Rocchio, in this case, has issued a permanent injunction against Measure 114. And now the State Court of Appeals has agreed with that decision and is keeping the block of Measure 114 in place. The case we're going to be discussing and breaking down in this video is called Arnold versus Kotek. The Arnold case is a state lawsuit filed by GOA, and then now also, I believe, Second Amendment Foundation, or SAF, is also supporting this lawsuit. This case challenges Oregon Measure 114 as a violation of the Oregon State Constitution. Despite the recent decision and permanent injunction that was issued by Judge Rocchio, the state of Oregon has filed an appeal up to the Court of Appeals there in the state and is asking for the Oregon Appeals Court to grant a stay which would halt the decision down below and allow them to enforce this magazine ban. Now, for those not familiar with Oregon Measure 114, let me explain generally what it does. Measure 114 will first require that anyone purchasing a firearm must obtain a permit to purchase. To obtain that permit, the person will need to complete a safety training course, go through a background check, get fingerprinted, show a valid ID, and only after that will they then get a permit to purchase. Now, under Measure 114, it will be generally unlawful for you to buy, sell, or transfer any firearms unless you have that permit. That rule will also apply to all private party transactions, so it's trying to restrict private party transactions. Now, under the measure, it's not isolated to just this permit process. The second significant thing that this measure did is it bans the sale, purchase, transfer, and possession of any magazine that holds more than 10 rounds after the effective date of the measure. So that's generally what this law did. Now, in response to that measure, the Arnold versus Kotek case was filed in a state court. In the Arnold state lawsuit, the Harney County Circuit Court Judge Robert Rocchio granted an outright TRO, which halted the permitting scheme and then also the magazine ban from going into effect. So there was a deadline for it to go into effect, I believe, in December of 2022, but it was halted and blocked with a temporary restraining order. And then subsequent to that TRO, he also had a hearing and heard a motion for a preliminary injunction, and then also granted a preliminary injunction. Again, preventing from Measure 114 from ever going into effect. Then he issued his final decision, again reviewed the entire case, and issued a final merits decision in this case. And ultimately what he did is he struck down the entire law, finding that it was invalid. In his order, Judge Rocchio stated that this court is preventing the undue burden of ballot Measure 114 from being imposed on current and prospective gun owners who have a right to lawfully possess firearms for the purpose of defending themselves and the state against imminent threats of harm. The court, using its equitable powers, declares and adjudges ballot Measure 114 facially unconstitutional in all of its applications under Oregon Constitution Article 1, Section 27. Ballot Measure 114 is permanently enjoined from implementation. Judge Rocchio ruled that the Oregon Measure 114 was invalid in its entirety, and he issued a permanent injunction striking down the entire law. But of course, the story never ends there. Oregon decided to file an appeal up to the State Court of Appeals. They also were then seeking a stay from the Judge Rocchio decision. They wanted the Court of Appeals to issue a stay against that decision. And what that essentially would mean is that Oregon wanted the Court of Appeals to step in, change the status quo of the law while the appeal is going on, and let Oregon, for the first time ever, be able to enforce Measure 114. Well, the judges on the Court of Appeals denied the state of Oregon's request for this stay, and they also decided to grant the expedited review of the merits review of this case, but also did some very beneficial things for the Pro 2A side. In the court's order, they state that respondents point out, and the court agrees, that in this case, unlike the usual case where a party seeks a stay to maintain the status quo while an appeal is pending, the stay sought by the state would do the opposite. As respondents say, stays of judgments are favored for maintaining the status quo, not upending it. And the status quo here is the pre-ballot measure 114 state of the law, which has been maintained to date. There has been no period of time in which the state could implement measure 114. They then go on to state that instead of maintaining the status quo, the state of Oregon asked this court to permit it to proceed with implementing measure 114, which has never been in effect, and despite that fact, at this point, it has been determined to be unconstitutional by the trial court. What the Court of Appeals is pointing to here is the clear fact that if they were to grant a stay in the favor of the state of Oregon, it would completely change the state laws. It would change the laws in regards to magazines and the ability to purchase handguns and rifles and other firearms. It would allow Oregon for the first time ever to be able to enforce this magazine ban, their permitting scheme, and the laws that were put in place through Measure 114. The court then looks at the likelihood of success of the merits of both of the parties in this case, and they find that essentially both sides have legitimate arguments, at least in the court's eyes. But since it's a tie, they believe in, their eyes that both sides have legitimate arguments, essentially the tie goes to the runner. The benefit goes to the Pro 2A side, and it goes towards keeping Measure 114 blocked and not changing the status of the laws. The Court of Appeals then also went on to reject the entire claim of that a significant harm would be suffered by the state and the residents of the state, the public at large, if Measure 114 is remained blocked, if they're not allowed to enforce it. The state of Oregon is claiming that there would be a significant amount of harm to the public. Now, the Court of Appeals here is rejecting that argument, and they claim that, this claim that there is going to be a significant amount of harm to the public is just entirely speculative. They state on this point that although the court acknowledges that the measure itself is intended to address an issue of great importance to the public, the motion does not present a sufficient basis to conclude that there is a non-speculative likelihood of harm that will occur during the pendency of the appeal in the absence of a stay. Therefore, based on all of that, the Court of Appeals denied Oregon's request for the stay. That means that the permanent injunction on Measure 114 remains in place while the Court of Appeals is going to review this case. The Court of Appeals also stated in their order that they will hold expedited hearings in this case, and so that's pretty significant. That's good news. I know the respondents or the plaintiffs weren't really pushing for an expedited review. The state of Oregon wanted expedited reviews, and they also wanted expedited briefings, but it was kind of a win-win situation where expedited hearings were granted, but then also the Pro 2A side was given the ability to have extended briefing, so more time to file their briefs and respond to what the state of Oregon is trying to do. The court concluded by saying that under these circumstances, it is appropriate to grant the state's request, also supported by amici, to expedite the case. However, having considered respondents' arguments against that relief, the court adopts longer timelines for the briefs to be filed, as compared to those proposed by the state. The state is, of course, free to take less time to file its briefs than is set out in this order. Now, I don't know if that was kind of a sleight of hand, maybe a little insult by the Court of Appeals to the state of Oregon saying, well, we're not going to rush these briefings, but if you want to file quick briefs, go ahead, do that. No one's going to stop you, but we're going to give everybody else the proper amount of time to file the briefs, and then we're going to try to hear this case as fast as possible. So now this case will move towards a final merits review in the Court of Appeals, but the denial of the stay is a huge win for those of you in Oregon. Measure 114 will remain blocked, and the likelihood is that it will never go into effect, at least while all this litigation is going on. Even if this case ends up eventually in the Oregon State Supreme Court, and maybe even eventually in front of the United States Supreme Court, there is a very low probability that a court will now all of a sudden let the magazine ban go into effect, this permit process go into effect, because it's never been enforced, it's never been allowed to go into effect. So a court now radically changing the status quo probably is just never going to happen. Big win for you guys in Oregon, because you also have a federal case right now that's making its way through the process. But unfortunately, that federal case, that I believe it's the OFF case, it's on hold right now in the Ninth Circuit Court of Appeals, and it's waiting for a decision by the Ninth Circuit en banc panel in the Duncan, California magazine ban case. So if you were just relying on that federal case, it probably wouldn't look super good for you guys in Oregon. But fortunately, you have a state court case here with this Arnold case where you've gotten a significant win. A permanent injunction has been issued. You're striking down this Oregon Measure 114, and the status quo is remaining the same for you guys right now. And again, if we get any more information, if anything else changes, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.